take Germany. Germany has an economy, say, 3 or 4 times as big as Australia's. It's got a more complex commercial community, of course, of its very size. The Germans can't understand how any commercial dispute could take 6 months. They simply don't understand it. They seem to be able to resolve their disputes in a quicker way. Now, it must be because they're prepared, it's a guesswork, but they're prepared to prepared to not overlook the niceties of cases, but not to spend so much time on things like discovery and so on. I don't know.
I was going to be a bit cheeky and suggest that Germans are very good at saying no, none.
Yeah, well, that could be right.
At least from what I've seen.
It's fascinating to see how other countries work. I mean, the Japanese are in a class on their own. I mean, this is my limited experience. I did do a bit of work for Japanese companies at the bar, but they would regard it as being almost infra dig to settle a case if they thought they'd done nothing wrong. If their lawyers said, well, look, that's okay, but we think there's some doubt about this contract or some facts, and my experience was that they were very difficult to deal with. As I understand it, was in my day, it's probably still the case, Japanese companies simply almost never go to court. They will somehow or other, I can only assume at a commercial level, reach some sort of compromise. I remember once being taken, of all places, to Nagoya to advise a Japanese company, which I had already advised in writing, had a difficult but winnable case in the Supreme Court of Papua New Guinea against the PNG government. That was a big commercial deal. So I was asked to go up and talk to their board of directors, which I did, and I said, in effect, well, we've got a difficult case, but if we win, the probability is we'll get 10 million kina. We could get 15, but there's no prospect of getting 30 kina, which I understand you people want. So they'd listen very courteously to me, they'd nod, they'd have a talk, and they'd come back and say, Mr. Moore, and I would say, well, of course, there's a risk. We mightn't succeed, but that's what I think. And I'd said this in writing. So I'm asked to go up to Nagoya with a solicitor with them. And they'd listen to me, and they'd go into a conference and say, Mr. Morling, thank you for your advice. We will win this case, and we will get 30 million kina, Just, they couldn't contemplate that what they wanted was what they'd get. I found it very difficult to handle.
But that might have had something to do with their cultural views about saving face.
Yes, you're absolutely right. You're absolutely right. And indeed, what happened in that case, would you believe, that they wouldn't run the case in the courts of Papua New Guinea because they wouldn't demean themselves by subjecting themselves to the scrutiny of a court. And what happened was the Prime Minister of Japan, they knew, was going to make a state visit to was back in Samari's days, a little way down the track, and they wised him up, and politicians settled the case. Samari was spoken to by the Prime Minister of Japan, and an Australian company wouldn't think of doing that. That's not our culture, However, the fact is that we do have, I realise this, when I say our system is, in my view, very strongly held view, the best way of arriving at the correct decision. It comes at the disadvantage of much greater cost. And if we wanted to say, we could say, our commercial committee could say, look to their lawyers, we just don't want to spend $500,000 on discovery in this case. We won't spend it. We'd reduce costs. But, we're not accustomed to saying that.
So, really good law is equated with having to spend more money? Is that your reluctant conclusion in all of this? Really good outcomes, I'm saying.
I think so. Not in every case. But you see, you can't run a case in medical negligence, plaintiff or defendant, if you're a solicitor, unless you say to your client, well, for the plaintiff, we think it's essential that we get 2 or 3 top medical experts to give us reports. Defendant says exactly the same. You're into big money before you take your next breath. You're into 6 top medical experts who are expensive. I don't know what the answer to that is.
No, and it's not easy to come up with a glib answer either. But what I don't mean to digress, but what do you make of firms that work on the no-win, no-fee type basis?
Well,
are they achieving goals, if you like, for law and justice?
I have to say, I have to recognise, unless lawyers did that, in the absence, which is unfortunate, of a decent legal aid scheme, lots and lots, most cases, genuine cases, could not be brought. There's just no way that hypothetical lady I'm telling you about, whose husband's is $60,000 a year bank clerk, could ever run a case. And I've got to say, I'm still a bit wary about funding cases, but nevertheless, I think I'm too old-fashioned there too. But I'm not critical now of lawyers who run cases on a no-win, no-fee basis.